This week is the annual spring meeting for American Bankruptcy Institute. At the ASM this week, the talk of the town doubtless is going to be this week's decision by the Supreme Court in a case called Mall of America Holdings, to be better known as MOAC. In this unanimous decision, the Supreme Court held that Section 363M of the Bankruptcy Code is not jurisdictional. For those of you who are not bankruptcy mavens, Section 363M says that the reversal on appeal of an order approving a sale does not affect the validity of the sale unless the order was stayed pending appeal or the purchaser was not in good faith. The circuit courts were split. Some held that that section is jurisdictional, which means there is no authority for an appellate court to review a sale of a bankrupt asset. The majority of circuit courts, however, held that that section is not jurisdictional. It is merely a limitation on the remedy that a court can grant in the event of reversal of an order approving a sale, or for that matter, a lease. Well, to me, the result was not the least bit surprising, because recent Supreme Court authority has indicated, as this decision said by Justice Jackson, that that section just does not have the unequivocal, clear language saying it is intended to be jurisdictional. But I tell you, here's the biggie in that opinion, and this is what I think folks are going to be talking about at the ASM this week. There are 2 pages of that opinion which could have a lot to say about whether or not there is validity to the doctrine known as equitable mootness. Essentially, Justice Jackson said in her opinion that we as an appellate court are not going to get into the issue of whether or not there is any remedy that is still available in the event of a reversal. And really, for me, that is part and parcel of equitable mootness, because the appellate courts say, hey, listen here, this plan has been consummated, you can't in any manner unscramble the eggs, so the appeal is moot. I think, however, that Justice Jackson is saying, in the context of equitable mootness, that the appellate court just shouldn't get into the issue. The appellate court should address the merits, because there is appellate jurisdiction on the merits and constitutional jurisdiction, and send the issue back to the lower court to decide what kind of a relief, if any, is available. I'm Bill Rochelle, the editor-at-large from American Bankruptcy Institute. I will return same time next week with something important about bankruptcy, but I bet you probably not nearly so important as the decision from the Supreme Court this week. Thank you and good day.